Well, can I welcome you all here and also welcome people who are online. Our idea this evening is to have a series of presentations and an opportunity for you to ask questions. I'm not going to introduce each of the speakers by reading out their CVs. They should be in the materials that were sent to you. But very briefly, I want to say one word about this bill. As a result of what is happening in the world today, UNCITRAL decided it would be one of the topics they would take into account, is looking at providing for electronic documents in international trade. And we're very fortunate to have Professor Miriam Elliott, who's going to speak about the work of UNCITRAL in due course. Her Majesty's government decided, on the advice of the Law Commission, that it would be a good idea if we enacted something that would work with the work that was produced by UNCITRAL. And we're very fortunate that the person who actually did all the work and produced a bill that has won universal praise is here tonight, Professor Sarah Green. We're then going to turn slightly to the nitty-gritty of the Act. And we're going to hear from Justice Fraser about that. And then we are finally going to hear from Sean Edwards in relation to the way in which it is anticipated this will work from a financing point of view and the benefits it should come. My only familiarity with this is that we have a very strange process of enacting recommendations of the Law Commission. And as in this case, the bill was uncontroversial, fortunately. There was a procedure which enabled it to be enacted quite quickly. And I saw a bit of the work of everyone concerned in this at that time. But all I am is an amateur looking at it. And I'm really going to now ask Professor Green if she would explain, as the Law Commissioner responsible for a little bit about the background. And then we will turn to hear from Justice Fraser about other questions. Yes.
Okay, thank you very much. I think with just looking around the room, I've probably spoken to a few people in this room already at various stages of this bill. And I know there were times when, as I was saying to Lord Thomas earlier, we weren't sure it was ever going to become an act rather than a bill. So it's very nice to be able to talk about it as something that is done and dusted, and now being able to do the work that we wanted it to do for such a very long time. So before I do come to the Act, I just want to say a few words for those of you who aren't aware exactly how the Law Commission works and what the process is for bringing these recommendations to government. Because as a Law Commission, that's of course all we can do. We make proposals to government, and then it is over to it to decide whether or not to take it forward. I don't think there was ever a huge amount of doubt on the merits and the substance of this Act, that it was going to be enacted if parliamentary time allowed. That is always the factor that we can't account for. But the really important point to note about the Law Commission, this wasn't clear necessarily to me before I took this job, so it is worth underlining, is that we are an independent body. We are not a government department. So what happens is we are funded by government, so that is the sort of slight apparent tension. But when government gives us a project, it is on the understanding that we carry that project through in a completely independent way. We do our own independent research. Most of what we do is based on consultation, so we consult incredibly widely, which is indeed why I have seen some of the faces in this room before. We hear from anybody. We don't put any limits on who we hear from. So anybody who has an interest, whether it is a reasonable interest or not in what we are asking about, we listen, and then we go away and we analyse the responses to that consultation. As I said, we combine that with our own independent research, and then we come up with proposals for government. So it's, in this case, it was 2 stages. There was a consultation paper where we put very provisional proposals out. We get responses to that, which we then analyse and put in a final report, and sometimes a draft bill, which is what we did. In this case, we have our own internal parliamentary council who actually put what we as commissioners and the team want the bill to do into statutory language, which is always amazingly impressive to me. I don't know how they manage to do it, but they do. Must be something to do with the 7 years training they have, but it is brilliant the way that they can do that. So that's what we did in this case. We presented a draft bill to government, which then went through the procedure that you've heard about as an uncontroversial bill. Really, that means politically uncontroversial, so we can't use that procedure for anything that is a political hot potato in any way. So quite a few of my commercial law projects would lend themselves to that, but my colleagues in crime and family tend to have fewer bills that would fit that process. Just before I talk about the bill, then, the final thing I would say about it in terms of law commission process is that it was unique, certainly in my experience, in that there was pretty much, we didn't encounter any real substantive objections to this bill. Everybody we spoke to thought it was a fantastic idea, thought it needed to happen maybe a decade ago. And so there was no objection at all in those terms. We did, of course, have quite a bit of discussion about exactly how to achieve the things that we all wanted to achieve. But overall, we didn't get any pushback at all on this being something that should happen. So what does it do? It's a very short act. It's really 6 substantive sections. And it's one of those things that when I look at it now, I do wonder why it was so difficult at times. In fact, the parliamentary councillor who drafted it said to me, and I do sort of wear this as a badge of honour, he said it was the most difficult bill, I should say, that he'd ever had to work on. And when you look at it now, it looks so simple, and that's great. We want it to be simple. But actually getting there, we did go through quite a few conceptual hoops. All it really does, I mean, in a sense, it is proper lawyer's law, but all it really does is ensure that the law regards electronic documents in exactly the same way as they would, or as it does, I should say, as it does paper documents. So it just requires any electronic trade document to replicate paper. And where that happens, it says that the result of that will be that the legal treatment will be exactly the same. Why was that necessary? It was necessary essentially because before that act, the law did not recognise that things it regarded as intangible could be held and possessed. And it's that really important concept of possession, which is so very important in the law of England and Wales, and that turns these the particular sort of commercial documents that we're concerned with. Possession enables this sort of legal alchemy. It enables those documents that can be legally possessed to give the holder rights that they would not otherwise have. So, of course, I'm sure most of you in this room know that if you are the holder of a bill of lading, that thereby gives you constructive possession and rights over the things to which that document relates. That couldn't happen in relation to electronic versions of those documents, partly because of the Bills of Exchange Act 1882. So that's been a bit of an impetuous change. And this is why we needed to change that so that these electronic trade documents could do the same thing. I think I'm probably going to stop there now. We are, obviously there are other people who are going to talk to you, and we will have time for questions at the end. I think in terms of an overview, that's probably enough for now.
If we want to go back to the procedure and how it all works, we can do that during questions. But I think the most important thing is to look how it's to work in the future. And so I'm going to now ask Justice Fraser to speak to us. He is the judge of the Property and Business Courts, as I was going to call them, He is going to become chairman of the Law Commission in a very short while. And so to him will pass the responsibility of hopefully this all working properly, but more importantly, looking at this as a model for further reforms that will have to be made to cope with the digital age.
Thank you. Yes, I take over at the Law Commission as the chair on the 1st of December. This isn't exactly hot news, but my main aim in terms of law reform, I realise I will never manage to have enacted, which is pass a law forbidding my children from borrowing each other's clothes without asking permission. Something which, having 3 daughters, squeezes me more angst than I think any parent I've ever dealt with before. Picking up on a point that Sarah made, where she said all the Act does is replicate the documents that you can achieve on paper. That is correct, of course, but it does require a conceptual leap by the law to equate physical possession, which the full passing of this legislation is obviously something that's been long standing with the concept of possession, or the equivalent possession of something that in real terms doesn't actually exist, or doesn't exist in physical terms. Now, if you take a step back and you look at the underlying purpose of trade documents, I mean, preparing for lodging some evidence in support with Lord Thomas's special committee on its perusing before I became involved in the Royal Commission for them. I was co-chair of a group with Sarah, and we have one of our number with Jonathan tonight on electronic signatures, where we had a cross-industry group, including lawyers and academics, looking at the whole concept of why, whether, or should electronic signatures be acceptable in English law as the equivalent of physical signatures. And that exercise threw up some similar concepts or concerns that some people have about electronic trade documents, which fundamentally goes to reliability. Historically, there were, going back to the Phoenician times, an entry in a ship's logbook was sufficiently conclusive evidence for the merchants to transport their goods by sea and sell them on at the port of disembarkation, with the purchaser being confident that they were buying goods to which the seller had title. And then in medieval times, obviously with the increase in maritime trade, much greater speed of transport, we have bills of lading and their close cousins, bills of exchange. And what those documents physically did is they give comfort to all of the people involved in the transaction, many of whom have nothing to do with each other either before or afterwards, and they break down barriers to wider trade. That's their fundamental purpose. Now, in the 21st century, obviously taking physical possession of a piece of paper in order to do that was lagging substantially behind the times. And it is true, there were trading platforms where seller, carrier, and purchaser could all engage on an electronic trade document basis, but they must all agree to do that and agree effectively in advance. And that is an obvious barrier to trade. If you think of the sort of thing that would have happened in the 18th century, that London, someone arrived with a cargo of any sort of commodity, coffee beans, tea, anything. The merchants who would be purchasing that cargo would not have any relationship with the seller at all, and they probably would have no relationship with the carrier. And so the document created an ability for that commodity to be traded. So when we're in the 21st century, and we will have more processing power on a single one of our iPhones than the Saturn V rocket and the Apollo module that landed on the moon, it's faintly ridiculous that an electronic version of the document could not replicate in law the same effect as a physical bill of lading or bill of exchange. So all the Act does really, so far as I'm concerned, if you want to one or two sentence summary, is it brings international trade into the 21st century in terms of that particular species of trade document. Now, there were discussions, I wouldn't say concerns, but there's been debate about reliability because sometimes the view is taken that an electronic document is perhaps less reliable or more open to replication or fraud than a physical document. Actually, the converse of that is probably true. Lots of the trading platforms work on different software models, but fundamentally, there's usually a distributed trade ledger or blockchain in there somewhere. They are probably more secure than a physical document. In any case, the physical document is perhaps not quite as secure as everybody probably thinks it is. And the level of reliability is certainly, arguably, no less reliable in an electronic document than it is in a physical document. And what the Act is not, this is effectively my layman's view of it, it's not expressing a legal opinion. What the Act does not do is seek to impose a counsel of perfection upon someone who's either dealing in electronic trade documents or wishes to write a program to create a system of electronic documents. And that's why reliability is dealt with, I like to think, in a fairly common sense way. The Act is groundbreaking. It is very simple in its terms as passed, but it does make a conceptual leap in English law in terms of electronic documents, which is why, so far as I'm concerned, it's a step towards keeping English law at the forefront of international trade. I mean, I did an unusual thing this morning. I went to a cash machine and I actually physically took out some cash. And I was going to wave one of the banknotes in front of you, but then I realised I forgot my wallet. But on the old banknotes, it used to say, I don't know if it still does, it might do, that was one of the purposes of getting the note out and reading it to you. I promised to pay the bearer on demand. And all a banknote really is an item of no value that represents extraordinary value in the case of the £50 note, or not so let's say, to the person who physically has it. And that's what a bill of lading and a bill of exchange does really, just for trade goods. And all this does is bring us forward into the 21st century. So I too think that's a thought is dominating.
As I said at the outset, we're very fortunate that we had an explanation e-test appears from England to now turn and look at the origins of some of this, and in particular, the work that was done by UNCITRAL. And who better than Professor Maringelli to tell us about how all that came about and speak a bit about the interrelationship of the regime unappropriated and the legislation we have passed in the United Kingdom.
Thanks, Lord Thomas. I'm not sure I'm the best person to talk about UNCITRAL, but I'm the only one here. The duty falls to me. So I was involved in the model law on electronic transferable records. In fact, I was a member of the working group that actually drafted the model law. The reason being that I actually started working on bills of lading and whether you could have a bill of lading in digital form back in 2003, so 20 years before the Act was actually came into force. September 2003, that's when I started my PhD. And I have published a number of papers, and the UNCITRAL Secretariat read my work and they decided they wanted to do a project on the subject. And they invited me to join the experts group and eventually the working group. And I attended the working group as observer on the part of, on behalf of CCLS. So I was representing my centre at UNCITRAL. And it was a very long process, but this is the law we eventually came up with. And you will see that even though the two laws don't use the same language, the model law and the Act don't use the same language, they pretty much do exactly the same thing. So as Sarah was saying, what they both do is plug into the existing legal regime governing paper documents that is based on possession, and they find a way to make that applicable to something that is not physical, that is intangible. So you have rules that were developed based on physical things which can be possessed, but you are finding a pathway towards applying those rules to something intangible. They both have a very similar scope. So this is the scope setting provision in the model law. It is talking about a certain type of document, a document which the model law describes as transferable. In that, in transferring the document, you are transferring the right to claim performance of the obligation in the document. The Act, is this working? Yes, it has worked. The Act pretty much has a very similar scope. It wants to cover the same type of document, so documents that function on the basis of possession. But we, and I say we because I was seconded to Sarah's team to work on the Act as well as working on the model law. We wanted to make it broader because some of these documents, some of the documents in the list that you can see in paragraph 2 there, they function on the basis of possession, but not as a matter of law, as a matter of custom, usage or practice. So we wanted the bill to be as broad as possible in its scope. Well, the next thing you can see is the definitions of electronic record and electronic transferable record in the model law. And you will see that it's not just the information that would normally be contained in one of these transferable paper documents, but also any data that's logically associated with that, so as to form part of the record. And this is very important because as the Law Commission put it in its consultation and report, you are looking for a data structure. You have to add a data structure to the information that constitutes the document in order to make it controllable. Without this data structure, that information is not controllable. And if it's not controllable, you don't have that analogy with possession that you need in order for the digital document to function in the same way. And this is the way we put it in the Electronic Trade Documents Act. You will see that it is very, very similar in the sense that there is that language of logical association of data that forms this structure. And obviously both pieces of legislation require that the information that would make a document a bill of lading, if it were on paper, is also in the electronic document. Basically, both instruments they also set out the criteria that an electronic document has to meet in order to be to be considered as controllable or possessable, so that it can function in the same way as its paper counterpart. So you will see that there are criteria relating to identifying the document, giving it an identity, giving it its own existence, making the document capable of being subject to control, and maintaining the integrity of the document, which is inherent on paper, because on paper what you do is you make permanent marks on a physical medium. So the notion of integrity is inherent to paper, but you also need to make sure it's being satisfied in the digital space. And you will see that the criteria are very, very similar. The language isn't quite the same, but we're talking about exactly the same criteria. We have integrity, so protecting the document against unauthorized alteration. We have identity and being able to distinguish the document from any copies. And you also have the controllability, which is in two parts in the Act. We have something called rivalrousness, which is that if one person has the document, no other person can also have the document, and divestibility, so that if you transfer the document to another person, you lose it. So these are the criteria. They are very in fact, they are identical in both pieces of legislation. This explains controllability and what it means to exercise control. And in section 3 of the Act, which you can see at the bottom of the slide there, it tells you what the effect is of meeting the criteria. If you meet the criteria, the document becomes capable of possession. It becomes capable of endorsement. So you can do with it the same things as you would be able to do with a paper document. So, and not only are you able to do those things, but if you do those things, they have the same effect at law. So there is equivalence, and that is why you need both subsection 2 and subsection 3 of section 3. And these are a couple of slides that basically give you a greater breakdown of the comparison. Essentially, as both Sarah and Peter said before me, the idea is to be able to do the same thing with a digital document as you can do with a paper document. And even though the Act does not use the language of functional equivalence in the same way as the model law does, so the language of functional equivalence goes like this. It goes, if the law requires, that requirement is met, right? So that language is not usual in English legal drafting. And there's been a lot of discussion of why, if it worked for Singapore, it doesn't work for the UK. Well, Singapore has adopted a number of UNCITRAL instruments, all of which use the language of functional possession, the functional equivalence, and therefore this language is very common in Singapore. It is something that in Singapore legislation, it's something they've worked with. They are used to it. They understand it, whereas it isn't common in English legislation, in UK legislation. Essentially, the Act does not use the language of functional equivalence, but it still plugs into the rules of possession and makes them applicable in the digital space, which is what the model law does effectively. So I think I'll stop there. Yes.
Well, thank you very, very much. We can come back to any questions you have about this, but the important point that's being made is that although at the moment not a large number of states have acceded to the UNCITRAL model law, MLETR, it is thought that quite a number of countries in continental Europe, the United States, and others will do so. And so it's absolutely critical that it is understood that the way we've done things, it will produce the same result. The bonus point is, as we may come back to it, is it may just give us, the way the UK has done it, may give a slight edge, because you can carry forward all the case law on possession, which may be useful in a point that no one has thought of. And that is why we've gone into this point in a little detail, because it's critical that there is, we've used the word rivalrous, which I'm sure I didn't learn when I was the age of many of you here. And the other thing we now talk about is interoperability, because obviously in the digital system, the whole system, the law and the systems have to be compatible, or to use the modern jargon, interoperable. Now, to show how this is going to work in practice, how it's going to make a difference to financing, and all kinds of figures have been given as to the huge savings this will make and how much easier it will all become. We're going to hear from Sean now, and he's got some really brilliant slides to try and explain the slightly more esoteric world of financing.
Thank you. Well, Thomas, so, I mean, the lawyers, and I'm a lawyer actually in my day job, lawyers have given us the rope. Are we going to hang ourselves with it? Is the question for the industry. Far from it. In fact, there are huge opportunities here. I'll explain some of those, but I want to start with a little bit of background to trade finance, trade and supply chain finance, actually, and how the new breed of digital trade instrument, digital trade document is going to plug in. So I'm going to start off with what I consider to be the most exciting slide in trade finance. So if you're sitting comfortably, you're ready. Put the clicker. And here it is. Are you suitably excited? If you were a banker, you would be very excited, because what this shows is actually your bankable universe if you're a trade finance banker. This is showing in the colored blocks, this is showing the physical supply chain. And in the little, the clear blocks of the stars above, these are the supply chain finance opportunities. And it starts, you can see, at the very beginning with planning your supply chain. So you're a manufacturer, an exporter, you've made nothing yet, but you want to export. So you start planning your supply chain, and you move all the way through. You find a buyer, you get an invoice, you get a purchase order first, you get an invoice, you produce it, you store it. At different points, there are different opportunities for supply chain finance. And I spend a lot of time talking about this slide when I teach supply chain finance at various business schools. The only point I'm going to make here in this context tonight is that the nature of the instrument, the value, both commercial and legal, of the instrument that you use at any particular point makes a great deal of difference as to whether or not you can finance that stage of the supply chain. So at the very, the blocks in the middle here are where banks have been actually very good at providing finance. So this is what we call payables finance or receivables finance. So at that point, there is an invoice or there's an acknowledgement of payment. And that makes it a lot easier for banks. And at some point, of course, it's not mentioned here, there's going to be a bill of lading to act as security. So the more we can digitize, and the bit at the beginning here, the pre-shipment finance, which you'll see there in the top right, purchase order finance, as it's called, that is very difficult for banks to do. In many economies, that is an overdraft. It's very expensive. If you are in an emerging market like Bangladesh, you are paying, upwards of 15%, probably a day. It's very expensive finance. There are people using digital systems to actually intervene at a much earlier point. So what we're talking about here has a real impact. And just one last point, actually, on instruments. There's a little bit of a division in the market between the transport documents and the financial documents. The bills of lading on the one hand, I won't mention that ships and mates receipts, because that caused a lot of excitement, I remember, during the evidence sessions. But basically, bills of lading and bills of exchange and promissory notes. That, I think, is a little bit of a false dichotomy. The two should actually transition from the physical into the financial. And that's one of the great, actually, promises that we have with digitization, which has been going on for a while, as I think Sir Peter said. We've had people like Valero and so on around for a long time. They've had to work through this closed loop, this contractual system, which has an innate cost limitation. Everybody has to be a member of that club. So we can now open it up, and that's one of our eminent vendors is in the front row here. So a few slides about, costing. Why are we doing this? Oh, I know, I'm getting suspenseful. So it's all planned.
Okay.
So if you read during the bill, there was a government assessment of the impact of the benefit, financial benefit of the bill, and they put it at a measly 1 billion sterling. Now, I think we all thought that was rather low, and I'll show you why in a sec. But where do the major savings come from? So actually, for many banks, it's a cost reduction saving. And you can see here, you can reduce costs by around 20%. Most of that comes from time saving, operational costs. That's really important for banks. In my view, that's not enough. You've also got to want to produce, I think, a network. But reducing time is you've got to get adoption, and that for many banks is why they're doing it. But when rolling it out and providing more efficient finance is actually, I think, the key, and this is what we're moving on to. So the figures I said, I think 1 billion is a bit measly. This is a study that was done by ICC for the G7. You'll see here some rather bigger figures than 1 billion. This, of course, is the global economy. And this is if we digitalize the whole of trade. So there's a lot more to do than just the trade instrument. That's a damn good start. So we digitalize the whole trade ecosystem, increase trade across the G7, so it's not the whole world, but the G7 countries by $9 trillion. This is a study I think was done in 2021. Exports could increase by 6 trillion. The reduction in costs here is very similar to what we saw the previous slide. 84% reduction in trade costs. Actually, that's not just for banks, but of course, the people on whom it falls the hardest are the SME exporters, for example. So a lot of that is around, reducing time. But very often reducing time means it's the difference between getting financing or not. The next slide, I will give you an example of something that did happen as a result of the time saving. This is a bit of a potpourri, and it's a little bit out of date. On the left there, you see what ICFA produced in advance of the bill. We produced something called the EPU, the Electronic Payment Undertaking, which was the sort of commercial equivalent of a bill of exchange and a prom note. and they were used, in fact, by the people on the right, by the likes of Lloyds and Mercor, using the technology of that company you see there, Inigio, which is a Swedish trade document vendor. Lloyds and a company called Mercor have been very active here. They've done prom notes, they've done bills of exchange, and they've moved. For the moment, actually, they've stuck to EPUs, either the prom note or the bill of exchange version. They are moving though to fully kosher, if you like, fully blown electronic negotiable instruments. And it is small at the moment, but it's beginning to scale. So the case that I did want to mention was one that was facilitated by Mercor. That was an import of sugar from Nicaragua by a company called Abacor. And it wasn't a very big import, a couple of $100,000 or pounds. They were able, by using at that time the EPU, but now the electronic bill of exchange, they were able to get the processing of the import and the finance done in 2 days. Without that, they would not actually have been able to do the import. So that sort of thing is going to scale up. I'd say it's small, but it's happening more quickly. The very last slide shows, I think, the evolution. So supply chain finance 2.0. This is one of our members, Taxpayer, using technology of a gentleman here in the front row. And what this is showing you is how you can transition across the supply, the physical and the financial supply chain using electronic documents. So you start with, as you can see here, it says 3 disconnected layers. When you digitize, you can merge them all. Now, in this case, of course, this is a sales pitch for this company, Taxpayer. But an open ecosystem of people using interoperable documents can work equally well. I think that the jury is still out as to who will win that particular commercial battle. The point is, we have choice. So you can do it through a platform. I'm also on the board of a Swiss fintech that has a similar platform. You can do it through that, or you can do it through freestanding digital negotiable instruments, as Taxpayer do. And with that, you have a single straight-through transition from the physical to the financial. You swap the bill of lading, the bill of exchange, or the promissory note. All that can happen on platform. That's the promise. I'll stop there.
Thank you very, very much indeed. And now this has been a bit of a whistle-stop tour. First, through the words, how it relates to legislation other countries may enact, and how very, very substantial sums of money can be saved and therefore trade improved by these new methods of financing. And I think what we should do now is allow some time. We've got probably 25 minutes for questions. But those who are online, if you have a question, please put it in the chat. It will come up with Pascal, who will be able to read it out to us. But can I then ask for a question from the floor? Yes. Right.
Yes, I don't really know who this question is best addressed to. Maybe the whole question to start with. But you were talking about transfer of possession and transfer of contractual obligations. But these documents obviously transfer title as well. So how does that work? Is that all dealt with by what you might call the background legislation?
No, so what we've done is what the Act does is enables these electronic documents to become documents of title. So it's exactly the proprietary interests that are transferred, because of course, as we've said, you didn't need to have, you never needed to have possession in order to transfer contractual rights, because that's obviously something that you can all agree to, which, as several of the panelists have said, is fine as long as everybody agrees to it, and of course as long as everybody's solvent. But then, as as soon as that is no longer the case, you want a proprietary right, and that's what the Act does. So sorry, I wasn't very clear about that.
But is that found in the Act, or is it found in the other legislation?
Oh, so that, sorry, yeah, so that sort of taps into, that's one of the reasons why we sort of went our own way in terms of how to present this Act. As Miriam's made clear, we get to exactly the same point that MLETR gets to. But one of the reasons we had to do that and sort of have our own particular path was so that we could say these documents can be possessed, which then feeds into the years and years of common law rules and assistance, really, that goes with possession. And it's possession that gives you those proprietary rights, which can now be transferred into the electronic forms of the document.
So essentially, what the Act does is it makes a digital bill of lading that meets the criteria a document of title. So the effect of transferring the digital bill of lading is the same as if you transferred a paper bill of lading. So in terms of common law, in terms of statute, in terms also of the applicability of the Hague Dispute rules, that this was the idea, that it would function in exactly the same way.
But I guess my question is, where do you look to find the rules on the transfer of property, in the new Act or in the old Act?
In the law on bills of lading,
Yeah.
which is a mixture of statutes and common law.
Can I maybe just add a gloss on that, which is how it's done? Because clearly we're not doing it anymore by a single method transfer of the paper. I sort of touched on this a little bit, but there are sort of two basic ways, and they're actually very well set out in the Law Commission paper. One is the creation of what you might call a native freestanding digital asset, but it happens to be a bill of lading or a bill of exchange. And that is, and this is what people like Nigio, who I've mentioned before, have done for the likes of Lloyds Bank, where you transfer using PKI, using public-private keys. The other method is, and this is what the fintech that I'm on the board of does, is to create a register. So the registry is actually where the digital registry. The registry is itself the means by which you create and transfer.
I suppose just one question, which is the other side of it, is how do you not transfer title? Like, for example, in the case of a pledge, where at the moment the bank can simply hold the document, doesn't get title to the goods. How do you achieve that in the digital world?
Well, the whole point of the Act and what we hope it will do is it simply substitutes. Miriam, can you go back to the slide that has something? It simply substitutes the electronic document for the paper document. So anything, I can't remember the exact words, anything that is done to a paper document has the same effect.
But how do you know that the bank is not the owner? That's my point. It has possession, but it's not in the current world.
Yeah.
Maybe not the current world anymore. It could be it could be in possession, but not the owner. It just have a pledge.
But
so how do you know the bank, which is now in possession, is not the owner?
In the same way as you know, on paper. So all the Act is doing is it's saying you can be in factual possession of a digital document in the same way as you would be in factual possession of a paper document. So if the bank would be in factual possession of the paper document, but the title is a matter of law, this is what the Act is saying would be the case with the digital document.
And maybe
because control is a matter of fact, not law, as far as the Act is concerned.
And all the restrictions on any one of the non-restrictions, the impact of the bank holding as a pledge the physical paper document now, all of the fact nobody else would have it, for example. They will be replicated if the bank were in the same position, but we're holding it as an electronic document.
And I think if Jonathan could just explain how, from the purely platform, it works, because I think that may answer your question.
Yes, so there are, it is very much, the legal effect is very much as Sarah has described. The way that's done depends, I say, a little bit on the system you're using, whether you're using a digital asset technology or you're using a registry. On a registry, where maybe it's a little bit easier to understand, actually, it would be possible to put on the register the fact that a bank was holding as a pledgee. And that might make it actually easier. And I'm not going to go into the debate about which of the two systems are better, because they both have pros and cons. But with a digital asset, I think you would probably have to have a look at what the factual background was to the holding of that asset, because you would hold it, you would be the possessor of the private key in that case. And you would have to, if it was necessary to assert the rights, you'd have to prove how, what your status was. So it's no different. Now, how different vendors are going to provide for that will make that easier. Actually, I think it should be easier than it is with paper. But we'll see how it works. On a register, it could actually be very simple.
Yeah, because you can put restrictions into a digital document. Obviously, you can't put into a paper document. So you could give somebody access to a digital document where their access key has restrictions built into it in a way that you can't with paper. So actually, it might even be easier.
Okay.
And the Act also keeps control and endorsement separate. So if in the paper world you would be transferring control or transferring possession without endorsement, because the bank does not want to become the holder of the bill, you could also do that in the digital space.
Okay. Shall we now move to another question? That one simple question having produced quite a lot of answers. Yes, up the back. I think next and then down here.
So it just is a gloss on what's just been said, because you talk about the register system. Is that a platform?
It would be on a platform, yes.
Okay, so that sort of makes sense to someone who's finding this all a bit. There's something independent and controlled, and the earlier slides about the security side of it, etc. It's being administered. What I don't quite get is the freestanding one. I don't understand how that's going to work at all. You don't have a register of that.
So that would work by transfer to control of to start with, and then transfer of the private key using that particular system.
Okay. You may need to explain the private key and how that's transferred. I think that is what I think.
That's what I'm getting. Yes.
One has to jump two things. You have to jump from the law being very simply changed to understanding the technology behind it. So if you could just explain a bit about private keys.
Well, this is where I confess to being a lawyer, so I'm a technologist. But it's effectively public-private key cryptography, and it can be done in different ways. One of our vendors here, one of our members here, uses quantum computing to create that asset, and then moves that. And this is actually the asset created in that last slide. By TraxMate, which is the idea is that you can, as the holder of that private key, then pass that on using effectively using the technology of that particular provider. And so there are, Lord Thomas is right, it's slightly more complex than handing over a piece of paper, not least because there are at least two broad ways of doing it, and even within those two broad ways, of course, there's going to be differentiations in the way the vendors actually do it. But the essential thing is you encrypt it, using your hashing technology that produces a public and a private key. That's probably about as much as I can tell you on the technology side. But you probably know more.
Well, I would say that even if it's standalone, there is still a ledger. Except it's a distributed ledger. It's not under the control of any one person.
Where does it exist?
It's distributed. It exists in various nodes, i.e. computers, servers, that are distributed across the world, and they are all synced up. But the important thing is that no one person has control over it. So there isn't a single point of control, and there isn't a single point of failure. So it's more secure as a technology than having a central registry.
Which is definitely one of the benefits of that. So it's blocked, largely blockchain or some variation of it.
And I think the reason that we could do this reform when we did it was because it was easily possible to replicate paper in this technological sense in a way that it hadn't been, say, 20 years ago. Because, of course, the problem historically with electronic things, so take a Word document. Obviously, I can send you a Word document, and I've still got that Word document. I could send it to however many people I wanted to, and we'd all have a copy of the same Word document. It wouldn't be singular. You wouldn't be able to have that as a document of title, because no bank is going to advance you any funds on a document of title that 100 or 1,000 people can have. And so that's exactly what this technology manages to do in a scalable way for the first time, is replicate paper in the sense of, I have this, it's electronic, I give it to Peter, I no longer have it, there is just a singular copy in effect. And what we talk about with the system is making sure that that happens. So a reliable system is one that enables only one person at a time, or one party at a time, to amend or modify or pass on this document. So that's what distributed ledger technology has enabled us to do. It won't be the only technology, but at the moment it's the most common one.
I hope that answers your question. We had one couple over here. Yes.
I'd love to take that offline, as the individual that Sean is kindly referencing to. I have the, I guess, double inconvenience of having trained at this wonderful institution and then been a banker for 30 years, and now looking at it from a technology angle. So take that as you will, but take that offline.
Yeah. Yes. Question. Yes.
Yes. How does it work? Do you use pins and code words and so on? How does it go from, say you have a transaction going through 8-9 people? How do they know it's the right people for receiving whatever is going through? Or is it all automated and there are no humans involved in the transactions?
I think it can be. But
Well, I mean, there are humans involved in the sense that there are various ways of doing this, and I'm very conscious I'm saying this with people like Dominic in the room here. But we spoke to, at the Law Commission, lots of various technology platforms who told us what was possible. And there are a variety of ways of doing it, but there is a sort of high level description. Dominic, do jump in if this is very wrong, but essentially it's like, I mean, to make an analogy with something that we're all familiar with, it's essentially a password. You get a password which is unique to you and to that particular stage of the transaction, and that password enables you at the moment to access that document and do the things that you should be able to do in your position in that contractual nexus. So it will give you certain access to the document, which you can just do through your laptop. So it's sort of, in a very basic way, like online banking. You get access to your account, you can do things in your account that only you should be able to do. And it's similar to accessing an electronic document, because you are given this unique password that enables you and only you to do certain things, or only the person who has that password.
And depending on the functionality of whichever platform it is, and just as an aside, I should make it obviously clear that the way the Act is worded is sufficiently generic not to direct any particular technological innovation in any particular direction. So in a way, it's for the technologists to build the foundations to allow end users to access their electronic documents. But depending on the way the platform does it, will either give you a certain number of features or attributes you can access, or restrict you from accessing them. But the fundamental thread which will flow through all of them is that you will be able to transfer your ownership in that electronic document to someone else, your possession of that electronic document to someone else who will then have exclusive rights to use it and deploy it and sell it on, etc., in the same way they would as if you were selling them a piece of paper of which they were taking physical possession. So it's really the last 2 or 3 questions actually have identified the conceptual leap you need to understand blockchain, but that is a purist way of looking at a digital asset rather than, for example, a register. Although they both probably achieve the same.
Can want to come in from here on that one?
I had a sort of more question about the legal innovation underlying it that the Law Commissioner talked about. I mean, if you think about it, you've done 2 things, and you've effectively tokenized the bill of lading,
Exactly.
the paper document, and then you've gone one step beyond that, and effectively you've given some sort of proprietary interest in the information within the token itself, right? So you've done 2 things. That seems to me to have quite significant repercussions for other uses of that conceptually, cryptocurrencies, non-fungible tokens. So what else can we tokenize? What else can we transfer using this other than just, trade flows? I'd be interested in your view on that.
I didn't pay Jonathan to ask that question, I promise, but we have done another project on all of that, which we published in June. Now, very quickly, I know we haven't got a huge amount of time, but actually you're completely right, of course, and the Electronic Trade Documents project is actually a subset of the broader project that we did on digital assets as a whole, and how English law, the law of England and Wales, I should say, should or needs to change to accommodate digital assets and tokens and NFTs and cryptocurrencies as commodities, not as currencies. That's not our remit. And we've come to exactly the same conclusion, really, which is that we need to deal with the possession problem, and we need to show how these things can be controlled and therefore possessed. What is it about them that replicates the sorts of things we're used to possessing, like laptops and watches or whatever? So you're absolutely right. To give you a very short answer, we've done a whole report on that. It's not something that we need legislation. For this, we needed to do legislation because it was a legislative problem that we had to get over. With digital assets in general, it's a common law problem of possession of intangibles. So what we've done with the digital assets report is provide really a framework for common law development and explain how these things are tokens and how they can be analogized with conventional assets and therefore not be denied proprietary status and proprietary recognition simply by virtue of the fact that they're digital. That, of course, does not mean that everything that's digital will get those rights, but if it can replicate a real world thing, if it's divestable, if it's rivalrous, if it's independent of persons in the legal system, could talk about it for hours, I won't, but I'm glad you asked the question. So yeah, it is exactly the same.
And if I could just add on a sort of general reform-based point, the aim is ultimately to enable digital things to be seen in the same way as their physical equivalents. So it's really the 21st century equivalent of however things were done in the 1980s or 1990s. The fact that it's done digitally in 2225, it shouldn't be treated in law any differently. Now, Sarah's right. This is a small subset of the wider digital assets picture. It might be there's room for digital assets bill in the near to medium term, who knows? For the moment, this is an important step in the trade world to achieve that equivalence.
We've had one. Let's come here first. And then, yeah. Yes.
I was going to ask, the Act talks about a reliable system, now small r, and the reliable system is actually used to identify the features of electronic trade document. But I wonder whether the Act actually defines what a reliable system is, because there's a lot of disparate systems, and there's no consistency as yet. This is what constitutes a reliable system. Or will that be actually taken offline? Will it be actually incorporated under the Act itself?
I'll let Peter talk about that in just a second. What I did want to say first is that part of your question, we deliberately didn't define a reliable system, because what we don't want this app to be is obsolete in 5 or 10 years. And what we didn't want to do then is, well, two things. One, we wanted to make sure that it isn't obsolete in a few years when technology has moved on. What we also wanted to make sure it was absolutely technologically neutral. And I think in defining exactly what we mean by reliability, a sort of checkbox, checklist, I should say, then we were in danger of not keeping to those two things. So we also didn't want to stifle innovation, and we didn't want to prescribe what a system should look like. All we wanted to make sure was that it allowed, as Miriam was talking about, for the integrity of documents, and howsoever the market wants to achieve that, then that was what we had in mind. But in terms of how that will be interpreted.
Well, I can't say how it will be judicially interpreted, but I can address reliability in a wide sense. And the first thing is asking yourself, really, what do any of us mean by something being reliable? Well, we really mean something that's sufficiently watertight such that it's dependable or trustworthy. And what the difference, I don't know who put slide 2.5.
Yeah, there we go.
Okay. What 5 does is it tries to set out the different features of which are likely to or may be taken into account when coming to that ultimate conclusion. Now, deliberately making it technology neutral means, I know Sarah said won't be obsolete in 5 or 10 years. Actually, probably means it won't be obsolete in 12 months, because it's very difficult in this fast-paced industry to predict what might be achieved or done in a year or two. And so what A to G tried to do is set out the different features that will be or may be taken into account if you're coming to an overall conclusion, which is ultimately a question of fact, really, admittedly, the technological foundation. Is that system reliable? And I think if you actually look through them, each of them are really, it's a common sense approach expressed as a number of steps or stages. And if any technological provider or innovator were to consider those different points, those are the features that they would be taking into account themselves anyway when they're writing the code. So, I had no input into HG, but if I were asked, if I had been given a blank sheet of paper and asked to write down the features for reliability, I'd like to think I would come up with a list of all similar to that.
It was a point that caused some concern, because people think of all the sort of scams that occur if you're an ordinary layman. But I think two things must be borne in mind. One, a system that is to be used in this way, one hope design various different systems. And second, you always have to make the comparison with paper. And that's what people don't know.
Can I just add one word about how actually we're going about this in practice? Sarah's already heard this with Friday. So we have these A to G criteria, and they are, they're not binding. You don't have to fulfill, in fact, any of them. Yes, in theory, although unlikely to be reliable, but at least some of them. The way the industry is done, I'm talking here just about the trade finance industry, is that we do seem to be going down the route of legal opinions based on assumptions, some of which are extremely broad, and in some other cases, reliability is being proved by a technical assessment, because actually, although it is, and I think the reason people are putting their, hanging their shingle or hanging their hat on the lawyers is because this is ultimately, I suppose, a legal question. Actually, the way, other than the rules of the system, which I suppose are purely legal, the rest of it really is technical. So there are some other vendors that are providing technical assessments. I think actually a mixture of the two, a well-supported legal opinion, not just making broad assumptions, is the way to go. And if somebody's nodding there, it's all right, I'm getting it right. So that's what we're seeing. The other thing that's worth bearing in mind is certification processes by people in authority, in quotation marks. In France, for example, where the law is likely to change at some point this year. There will probably be some sort of central certification. Here in the UK, ICFA, my trade association, ICC UK, and C4DTI are looking actually at an accreditation process and sort of approval that can be described as an MOT for that will take about a year to come to fruition. So we're going down. We're finding good practical ways of solving it.
But this is merely a matter of industry having confidence.
Yeah.
They've got nothing, there's no legal requirement for certification. There's absolutely nothing. Yeah, I think we've got time for a couple more. We've had
This will be very well. It'll be very short because thank you for the last question. A lot of what I was going to ask has been covered admirably. But the one key question I did want to ask is those A to G are very closely aligned with the MLETR model law, as you know, the conditions that they lay down for assessing reliability. But in addition, they have the provision sitting at the end that we did not include in the Electronic Trade Documents Act, that something which is proven in fact to have fulfilled the function by itself or together with further evidence should also be regarded as reliable. And please, could you share with us? I realise it was discussed in the House of Lords Committee, this issue, but why do you think we did not need that provision?
So that provision doesn't create a presumption of reliability. It simply says there's no need to prove reliability if the system has in actual fact performed its functions.
Yes.
And thinking back to the discussion behind that provision, and also looking at the explanatory note that comes with the model law, the idea was to basically preclude frivolous or vexatious litigation, where a party is made to prove reliability, to go through the expense of proving reliability when there is no evidence of unreliability. So that was the idea, really. That was what we discussed in the working group. Now, I don't remember precisely why it was decided to leave it out in the Law Commission, but when it comes to litigation, this jurisdiction already has very detailed, civil procedure rules, I'm not a judge, and my view carries very, very little weight. But I doubt that a court would make a litigant undergo the expense of proving reliability in a situation where there's no evidence of unreliability.
I've got a heckler.
I've got a heckler.
I'm not sure if
So yes, I mean, this is just my view. I'm not putting words in anybody's mouth, but
it was as we talked about when we were. I mean, as Miriam said, she was seconded to our team, which was invaluable for doing this because, of course, we have MLETR. And it was described to me at the time that it being a model law, of course, it was never intended to be a plug and play thing. And so really it's a menu, isn't it, for jurisdictions to pick the things that they need and that slot into their own systems. And as Miriam said, we just didn't think that was something that we required. And the other point that I've often, and people in this room will have heard me say this lots of times, but it does bear repeating, is when we're doing law reform, and particularly with commercial law, what we're trying to do is laparoscopic legal surgery. We don't want to interfere in anything that works. and try and do too much when what we are focusing on is a very narrow and important point. So anything that we didn't think we absolutely needed to change or to say in this act, we didn't. We just kept it. So, I mean, this is, as you might imagine, what you are seeing before you now is something like the 120th draft of what this looked like. And it was probably in there at some point, but it didn't make a final cut.
Because the concern I had is this example. If a promissory note is subject to dispute, and the obligor is saying, no, I don't have to pay under that digital note, because the system on which the note was put is not reliable.
Yeah.
But the note itself might contain the very core details that really prove, in fact, that yes, that obligor is the one who is liable on the note and should pay. So I felt that particular additional provision might give an element that justice could prevail. Or do we simply say, well, no, actually the system doesn't mean the entire platform. The system needs to be reliable only insofar as the specific claim that is being put can be shown to be reliable.
Well, in that example, if it went to litigation, there'd obviously be an issue of fact for the court to decide is it reliable. And I don't think a general complaint of unreliability without specifics would get very far. And I also imagine it would be unlikely that the party seeking to rely on the note would have to ab initio prove the reliability of the entire system in order to enforce the note. But obviously it's impossible to say.
Thank you very much.
That's
Thank
how
you. Yeah.
I mean, it's a classic, in a situation where you allege fraud, the first thing you have to do is you have to particularize what fraud is. If you say, particularly if it's a widely used system, if it's unreliable, well, the first thing you have to do is you have to particularize why you said it's in what. Otherwise, you're probably going to struggle.
I think we've got time for one more question. Yes, yeah.
What worries me in that is it doesn't tell me only G goes to the standard of reliability. I mean, you can have a surgical procedure which goes wrong once in 1,000 times, and the surgeon may sell it to you as reliable. But presumably it's not acceptable if a bill of lading system goes wrong once in 1,000 times. It needs to be a lot less frequent. But nothing tells us how much less frequent unless it's an industry standard under G.
Well, E does as well. If there have been regular gold standard audits done by a respected body, then surely that's a factor that weighs in favour of reliability. I would have thought that sort of equivalent weight to adopting a voluntary scheme, as with F, probably.
Yeah, and there's also the point that, remember, I mean, this is what I've said quite a few times what I did say quite a few times when we were meeting during the consultation process is, well, what you've just described statistically is certainly better than we get with paper. If we were starting from now and trying to decide how we were going to transfer these rights and obligations and deal with all this financing, and somebody said, let's do it through paper, you'd think they were crazy. So we're only comfortable with paper because it's a familiar risk or a familiar set of risks. And as Peter said at the start, actually the electronic documents come with a different set of risks. And I think in aggregate, they're a lot lower than those that relate to paper, but they're unfamiliar. So as humans, we find them more difficult to accept. But I mean, yeah, the fallibility of paper is huge, but we've been content with that for centuries. So I think that's what we were trying to get at here is there are sort of little things that you can do that can make a particular system or give people more comfort, I think, in relation to that particular system. The other point is, of course, I mean, if you're going to go into the market and use an unreliable system, this is probably the last of your worries. I mean, why would you do that?
You're not going to get many customers. Yeah.
Well, I think the question that you've asked really sums up, I think, where we've got to, which we've had a wonderful explanation of its origins, how it relates to the meter, which is critical to the way in which this is to work in the future. The real question is, to what extent will those in the market use it? Jonathan has been very encouraging, and Sean has been very encouraging in saying that the amounts of money that can be saved and used for better purposes with this will maybe make it attractive. But one will just have to wait and see what bankers, what ship owners, and others who prefer bits of paper make of the future. But can I thank everyone on your behalf for a very interesting discussion. There's a lot, but here I think one is in the box of looking into the future and see what happens.
I just want to say, I'm sorry I came late. I didn't see all this wonderful stuff, but I grasp the meaning of it, and I will look at them if they record it. I can sense in this room there's a lot of people who know the digitalization. I can sense you are very advanced and you understood what was said, and you encourage the market to take it up. But my big question is, knowing the Greek market too well, is the ordinary ship owner in his desk going to say, I'm going to buy this up? It's too abstract for him. So he will need to engage digitalization in his office in the operations to make it work. Thank you very much, Lord Thomas, for encouraging us to have this on the stages of this event. And to all of you who are so clear and worked so hard, because I've been watching you, and to Miriam for spearheading. Thank you all.